Ladies and gentlemen, good morning. This is an interesting topic to talk on today because Tessa asked me to provide guidance for agents and Douglas guidance for landlords. But as you've heard from David Smith and Anne this morning, we don't know what the law is yet, and therefore it's quite a challenge for us to provide guidance on something we don't know what the rules are going to be. So I think we're going to talk about our views on the bill and on the Housing Wales Act and also on the Renting Homes Bill, and give you some sort of as much guidance as we can actually provide. There we go. I suppose I'm going to start with when it was initially introduced into the Senedd, the Welsh Assembly. We were very supportive at ARLA of the concept of the bill. We've been campaigning for 20 years for greater regulation of letting agents, and the face of the bill was sensible, appropriate, and we thought it struck the right balance, and really Wales was leading the charge in the UK and the legislatures of the UK for appropriate regulation of letting agents. I'm sure you can sense there's a but coming, and I'm afraid there is a but coming. It got watered down to such an extent during its passage through the bill and now into implementation. We're worried that it's really not going to change the situation a great deal. All it is going to do is add a huge amount of administration and bureaucracy. And really, from the letting agent's point of view, and can I just ask very quickly, for a quick show of hands, how many letting agents do we have in the room, please? Oh, wow. And how many landlords? We're about 50-50, actually. I'm going to talk from the letting agent's point of view. I'm going to leave Douglas to talk from the landlord's point of view. But from the letting agent's point of view, they had in the bill itself, when it was proposed to the Welsh Assembly, a requirement for all letting agents to be a member of one of the trade associations, one of the regulatory bodies. They took that out literally at the 11th hour on the day the bill passed. It was one of the final amendments that were agreed, and we were exceptionally disappointed. And I wonder whether the Assembly members realised what they were doing when they took that out. Because with requirements to be a member of a professional body came the client money protection, came the independent redress, the auditing of client accounts, the requirement to have continued professional development, all the things that we argue are the benchmark and the basis of regulation of letting agents, all that are required by the professional bodies, which got wiped away by removing one sentence from what became the Housing Wales Act. Now, for the landlords in the room, we think that the client money protection aspect is the most important. If you're going to be required to give your property to a licensed agent if you don't want to rent and manage the property yourselves, should it not be your right, your expectation that that person knows what they're doing, and that if things do go wrong, there is a safeguard in place for you? It's why all ARLA agents for many years have had to have client money protection. It's why RICS members have to have client money protection, so that in the event that things go wrong, that an agent misappropriates your funds or goes bust, ARLA, RICS will give you your money back, and we do that. So we were very disappointed that this got taken out at the 11th hour. We've been fighting very hard to get it reinserted under secondary legislation. Certainly, from what Anne has said, it's likely it might end up back in the bill, but it should really have been on the face of the bill, and we were very disappointed that it wasn't. Which is why I've got down there, is it now nothing more than a nationwide selective licensing scheme? Because really, from what we're seeing coming out of the Welsh Government at the moment, it's all about administration. Everybody has to register. They have to register their properties. Yes, they have to do some training on top, so it's sort of selective licensing plus, but it seems to have turned from a sensible approach to regulating the industry to a data gathering exercise. Is that really what the intention of the bill was? Is it really what we want from Wales? We know that selective licensing doesn't work. It doesn't work anywhere in the country. There are 50 plus local authorities that have some system of selective licensing across England and Wales. We've got Cathays in Cardiff, we've got Wrexham as well. The only scheme that has actually achieved its aims was the London Borough of Newham, the first and the largest scheme in existence at the moment, which covered the whole borough 40,000 plus properties. Everyone had to get a license, and everyone has to get a license now because it's still in force. But when the Mayor of Newham did that, he was well aware that he was creating the largest scheme. He dotted every I, crossed every T, and pumped millions of pounds into enforcement. He took a big political risk by creating that scheme, and it has actually paid off. There were a lot of people that were very critical of that scheme in Newham, but he got resources, he diverted resources from inside the council, he got resources from central government, from European funding to actually enforce the scheme, and it is working in Newham. And that brings me on to my final point on this one. What about enforcement? So far we've had 3 consultations, there is still 1 outstanding, and I would encourage you to respond to that. But nothing yet, not a squeak from the Welsh Government about how they are going to enforce this scheme. And by the sounds of it, they're going to pass it down to under-resourced, understaffed, and overworked environmental health officers in every local authority that we already know are not enforcing the regulations as they at the moment. Why do they think that imposing more regulations, more enforcement, when it's not happening at the moment, is going to achieve the aims that it wants? Which is why we are quite critical of it at the moment, and we are hoping that when we get more details out of the Welsh Government, they are going to reverse some of the mistakes they've already made. I'm going to look at the various bits in detail now, and we've kind of broken it down into 3 parts: the qualification requirements, the code of practice, and the actual licensing requirements. And this one is very agent focused. The qualification requirements, it looks like it's going to be a minimum of a 1-day training course. Now, that might be okay for landlords that are managing 1 or 2 properties themselves. They can get all the key information in 1 day. But for a letting agent that is managing tens, hundreds of properties, and some of the larger agencies, thousands, if not tens of thousands of properties across the country, is 1 day sufficient? Will you all leave today thinking, I have learned absolutely everything I need to know about running a lettings portfolio? It's just not possible to teach that volume of information in 1 day. It's why our qualification takes 120 hours of study to go through a lever arch file of paper to learn what they need to do. You just simply cannot impart that level of knowledge and level of information in 1 day, which is why we are highly critical that the Welsh Government are looking at the lowest common denominator rather than creating a professional qualification and professional standards for professional industry. And when you think, for a landlord, it's the largest asset that you've probably got, your rental properties beyond the houses that you live in. For a tenant, it is their home. Should you not expect, should it not be your right and your tenant's right that the letting agent that you are being required to use by law knows what they are doing, and they just simply cannot get that information imparted in a 1-day training course? There's also now no longer a requirement for continued professional development, and that hits our final point of the impact of the Renting Homes Bill. Because as it seems to be at the moment, the licensing requirements of the Housing Wales Act will come into force at some point later this year. There will then be a 12-month window to get trained qualified before they start enforcement 12 months later. So probably sort of end of 2016, they will start looking at enforcement, which would be fine if we didn't have the Renting Homes Bill going through the Senate and the Assembly at the moment that may entirely change the legislative landscape and the tenancy regimes in Wales. And because there's no requirement for continued professional development, everybody will have got trained in effectively English law, as it stands at the moment, for 6 months later to then have the entire tenancy regime changed, and no requirement for them to update their knowledge element of what they need to do to be a letting agent. Now, it's something I gave evidence before the Welsh Assembly yesterday on the Renting Homes Bill, and one of the points that I made is that they've done it the wrong way round. If they were going to impose this, they should have changed the tenancy regime first, because otherwise people are getting trained on information that will be out of date 6 months after they've got trained. Which is why they need to put some level of continued professional development into the requirements. Looking at the code of practice, actually this is the one that the consultation is still open. It's open till the end of next week, and actually the code of practice is sensible. It's clear, it's concise, it sets out the key musts and shoulds. Musts, the legal requirement, shoulds, the best practice, in an easy-to-read form for landlords, tenants, and agents. It's not particularly detailed, it is a very high-level code, but certainly for letting agents, every ARLA agent has to be a member of, or has to abide by the Property Ombudsman's Code of Practice, which is a much more detailed, probably the most detailed code in the sector. And having spoken with the Property Ombudsman, there's nothing that is in the Welsh draft code that is not just vastly more detailed in the TPO code. So we're not too worried about that. It's unlikely to conflict with the TPO code unless they change it. It's unlikely to conflict with the RICS Blue Book. But one thing I would urge everybody is to have a look at it. It's about 20 pages long. It's on the Welsh Government's website at the moment, and do reply to the consultation by the end of next week. Sorry, I'm afraid I can't see the slides. Licensing requirements. This is an interesting one. On the positive side, the timescales that they're proposing in the recent consultation are sensible. Processing the registrations within 28 days, processing the licensing applications within 8 weeks. Sensible, but are they going to achieve it? I'm sure people that have experienced the licensing in Cardiff and in Wrexham know that it can take weeks, if not months, to get the actual licensing through, and it's not unique to Cardiff and Wrexham. Pretty much every licensing scheme in the country, they do not actually meet their SLA agreements to get the licensing processed on time. And one of the things we put in our consultation document is that actually Brussels helped us quite a lot on this one a few years ago. And under the Services Directive from Brussels, local authorities are required to automatically approve license applications if the local authority fails to meet the service level agreement, so the 4 weeks or the 8 weeks. The consultation didn't make any reference to the Services Directive. I know Anne had it in her presentation this morning, but we are strongly arguing that if Cardiff Council is not getting them through in sufficient time, they should be approved automatically. And what sort of evaluation is there going to be? Again, in the consultation document, it to a large extent seems as though Cardiff Council has just been given a blank cheque to do as they want. There doesn't seem to be any monitoring, any evaluation of actually how this is working, whether it is working at all, whether it is achieving any of the aim. So what sort of evaluation of how they're administering the scheme, how it is working, there needs to be some level of evaluation. Otherwise, it is just effectively a blank cheque to Cardiff Council. And the resources are an interesting one, because having looked at what they require, I'm not sure whether they have fully appreciated how much they are going to be expected to administer. Just for the letting agents in the room, just a quick show of hands, how many of you have employed a member of staff in the last 12 months? How many of you have employed multiple members of staff in the last 12 months? How many of you have lost a member of staff in the last 12 months? How many of you lost multiple members of staff in the last 12 months? Quite a few. Now, under the requirement, I'm just going to talk about the letting agents ones at the moment. Under the requirements at the moment, it seems to indicate that, one, everybody involved in lettings is going to need to get trained, which we're not massively concerned about, but we have to think about things like back office staff. I can understand negotiators, senior negotiators, lettings managers, branch managers, people that are client facing. But does the person that sits in the back office and processes the fees, processes the reference requests, prepares the tenancy agreement, is it really necessary for them to go through the full training when really it is an admin and support role? One of the questions for the larger agencies is if you've got hubs outside of Wales, are they going to need to get trained and qualified as well? How is that going to work? But if you have to notify the Welsh Government, and this is what the requirements are, notify the Welsh Government every time you have a staff change. So, for example, if I left yourself, sir, and went to work for you, you would need to notify the Welsh Government that I've left. You will need to notify the Welsh Government that I've arrived. You'll probably replace me, so you'll need to notify the Welsh Government that you've taken somebody else on, and I might be replacing somebody else, so you'll need to notify the Welsh Government that somebody else has left. At which point, for one change of staff, you've got 4 notifications. Think of the sheer volume across the entire lettings industry of changes in staff and how many notifications are going to be required. And then we get onto the landlords as well. So a landlord will be required to notify every time they sell a property, every time they buy a property. If they change from managing it themselves to using a letting agent, they'll have to notify. If they change from one letting agent to another letting agent, they will need to notify. The sheer volume of notifications, I think, have been fundamentally underestimated. ARLA has about 8,000 members at the moment, and I employ 27 staff to make sure that my members are complying with their requirements as members and doing the administration. And that's for 8,000 members. And I only require them to notify me once a year of changes in circumstances. If they are required within 28 days, as is the current proposal, to notify the Welsh Government, I think they have fundamentally misunderstood quite the volume of work they are going to have to do. And unless they are going to employ an army to actually do all of this processing, they're setting themselves up to fail. And using an IT system and getting it done online or otherwise, I use an IT system. Any ARLA agents in the room will be renewing online this year. It doesn't really reduce the actual manpower in making sure that they do it. At which point, if they do not adequately resource it, it's going to end up with the professional agents and the professional landlords doing it properly and everybody else operating under the radar. And this is where we get to the fees, because in the proposal, it talks about Cardiff Council will be able to set the fees that they want, and effectively have written a blank cheque to Cardiff Council on the fees element. Now, what recourse are landlords and agents going to have if they set the fees sky high? What are the fees going to cover? It doesn't set it out in the document what the fees are going to cover. And therefore, this is why we're advocating that some sort of industry body is set up, some sort of oversight council is set up to actually monitor and police what Cardiff Council are doing, because at the moment they have a huge amount of power under these proposals, and it is what we raised yesterday. Actually, Douglas was giving evidence as well before the Welsh Assembly yesterday. So in principle, it was a good idea. We're worried it's not actually going to achieve the aims. We're worried it's not going to become anything more than a paper-based exercise, because simply there is not going to be the resources and the enforcement available across Wales. So it's a sort of salutary lesson and comment to the Welsh Government that they really need to think about this in the last few months as they are putting it together. Otherwise, it's not going to achieve the aims that they hope and we hope it will do. Having said that, on a slightly more positive note, I'm going to talk about the Renting Homes Bill very quickly. I'm conscious I've got a few more minutes left. Renting Homes Bill, on the other hand, we think is actually quite sensible. There's a huge amount of legislation governing the private rented sector. I think the ARLA talk about 100 Acts of Parliament, 400 sets of regulations. This wipes away an awful lot of that and puts it all in one place as an overarching change to tenancy regimes, but it doesn't actually change it a great deal from what we exist at the moment. A model tenancy agreement should make it easier and help landlords and agents not fall foul of the Unfair Contract Terms Act and the Unfair Terms in Consumer Contracts regulations. They're keeping the no-fault possession, and if any of you operate in Scotland as well, in Scotland they are undertaking a very similar exercise, but are probably about 12 to 18 months behind the Welsh Government, but they're looking at getting rid of the no-fault possession altogether. So the fact that the Welsh Government are proposing to keep the no-fault possession and also wipe away the 6-month security of tenure, again, we think that is a positive and will encourage landlords and agents to take people that maybe they wouldn't have done, maybe who were a higher risk because they've still got the no-fault possession and they've got the loss of the 6-month moratorium. They've also created an abandonment ground, which whilst I'm a bit concerned about the wording, and I'll come back to that one in the concerns, it's actually a positive step. We do have a few concerns though. It's something that I was actually talking to Simon from the Bill team this morning. They've taken away the common law requirement to act in a tenant-like manner. At the moment, tenants are required by the common law and case law to conduct their tenancy in a tenant-like manner, not damage the properties, not have wild parties and disrupt the neighbours. For some reason, they've wiped this away and not replaced it on the face of the bill, and it was something that the Bill Committee asked me about yesterday. I can't understand why they're doing it, because they're talking in the notes about putting it back in at secondary legislation, and it's something that I asked the committee to quiz the Welsh Government and quiz the Minister on when she goes before the committee next week. There's also a requirement under the common parts, so it's clause 92 of the bill, if anybody is so inclined to read it, that seems to make the landlord responsible for obviously their own property and keeping their property in good repair. Now, that is merely replacing the existing law, so we've got no particular problem with that. But it seems to also extend it out to the common parts, so particularly blocks of flats. And something I argued with the Bill Committee yesterday was that landlords are not responsible for the common parts of a block of flats. That's the freeholder, the managing agent. There may be multiple leaseholders. There may be consultation requirements if works are going to cost more than £250 per leaseholder. Can a landlord be responsible for that, and can that interrupt tenancy law when the landlord has no control whatsoever over what is going on in the common parts? And I'm hoping that when it comes to amendment stage, they will amend those pieces of that particular piece of legislation to make it clear that a landlord is responsible for what they are in control of, their property, not what they are not in control of. There's an interesting one, and the term is suitable alternative accommodation, and it comes back to the abandonment ground. Under the current proposals for abandonment, you'll be able to regain possession of the properties within 4 weeks, which is positive. However, they put a clause in that if the tenant comes back within 6 months and says, I didn't abandon the property, I want my tenancy back, the landlord will be required to provide them with alternative accommodation. Thought you'd like that one. And what it actually says is that it will require the tenant and the tenant's family to be provided with suitable alternative accommodation. Now, the point that I've raised is that if somebody rents a studio apartment in Cardiff, lives there for a few months, disappears and gets a 6-month tenancy because they've got a 6-month work contract in Swansea, come back, they can actually have a full other tenancy somewhere else and say, actually, I didn't abandon this property, I want it back. And I rented a studio flat, but I'm now coming back with my wife, my 2 children, my parents, my brother and my sister and their children, all classed as one family, at which point, what started as a 1-bedroom flat, the landlord will be required to provide a 10-bedroom mansion. Suffice it to say, this one has been raised with the Welsh Government, and I'm hoping it was merely an error in drafting. I cannot imagine it was the policy intent. But we're saying that, the period from 6 months should be reduced to 2 months, because if somebody has legitimately abandoned the property, they're gone. If they haven't legitimately abandoned the property, one would hope that they would be back within 2 months of leaving. And therefore 6 months is far too long. And suitable alternative accommodation, you have to provide the tenant with suitable alternative accommodation, not necessarily their whole family. Last concern that we've got is retaliatory eviction. A lot of organisations, including both ARLA and the ARLA, spend an awful lot of time talking about retaliatory eviction. We don't think it is anywhere near the problem that it has been made out to be, but there are provisions for retaliatory eviction in the bill. However, they are very widely drafted and effectively left up to the courts to decide whether or not it is retaliatory eviction. We are arguing that, particularly under the no-fault possession ground, that will open up landlords and agents to frivolous, vexatious claims of retaliatory eviction, prolonging possession proceedings. So we've actually suggested that the Bill Committee goes and looks at what Westminster has put in the Deregulation Act, which will be coming into force later this year, as a suitable model of dealing with retaliatory eviction. And what the Deregulation Act says is the tenant needs to make a complaint, written complaint to landlord or agent. Landlord or agent has to respond within 14 days with what they've called a reasonable response, so acknowledging the problem, saying what they're going to do to fix the problem, and saying when they're going to fix the problem. You don't need to fix the problem within 14 days, you merely need to reply saying you're going to fix it within 14 days. If the landlord or agent doesn't do that, the tenant goes to the local authority does an inspection, and if they serve an improvement notice on the landlord can't use Section 21 for 6 months. Now that gives the landlord plenty of opportunity to fix the problem. If they're just unwilling by the time it gets to an actual improvement notice, then I'm afraid on that one, the landlord only has themselves to blame if they lose their Section 21 rights. But we are saying that that is what the Welsh Government should be looking at and the Welsh Assembly should be looking at, not we'll just leave it up to the court system to decide whether or not it's retaliatory eviction. And the last one, we are pushing for specialist housing courts. For people that have had to regain possession recently, one of the things we hear on a very regular basis from agents is that the county courts are massively overworked, underfunded, the judges don't know the housing law, and therefore in a lot of contested hearings, the agents, the landlords, the lawyers are having to explain recent case law changes to the judges in order to let them actually adjudicate and make a decision. We're arguing for specialist housing courts and actually to take housing and possession claims out of the county court system altogether and do what they're doing in Scotland, which is creating the first tier tribunal with specialist housing judges that will be trained in housing law matters, will deal with housing law matters day in, day out, so will be up to date in all the laws, and hopefully it will speed up the possession proceedings. The committee seemed quite keen on that one yesterday, but we will have to see where it goes over the coming months.